Hello and welcome to Sacramento Justice League's series on criminal record review and expungement. This video is for folks that are not eligible for expungement, but instead need to obtain a Certificate of Rehabilitation and a governor's pardon. First, a few disclaimers. Nothing in this video should be interpreted to constitute the formation of an attorney-client relationship. This video is not intended as legal advice, it simply provides legal information. For specific questions about your situation, you should contact your local public defender or contact us. Contact information is in the description below. This video highlights procedures in Sacramento County, but for information specific to a different county, you should contact your local public defender in that county or the legal aid office there. And finally, laws change frequently and are subject to differing interpretations. It's your responsibility to make sure the law has not changed and that it still applies to your particular situation. In this video, we'll tell you a little bit about what Sacramento Justice League is. We'll talk about what a Certificate of Rehabilitation is. We'll talk about how it can help you and how it is limited. And we'll also talk about how you can get a Certificate of Rehabilitation. You may also want to take a look at other videos in this series, including getting a rap sheet if you do not yet have your criminal record report. And if your crime is less serious and you don't need a Certificate of Rehabilitation, how you can read your criminal record report and expunge a conviction. Let's start with a little bit of information about what Sacramento Justice League is and what we do. Sacramento Justice League is located in Sacramento, California. We offer the community free or low-cost legal services. We're a team of attorneys and other advocates, and we're here to provide legal services to the community regardless of an individual's ability to pay. We offer legal clinics on a sliding fee scale depending on one's income, and many of our clients qualify for free counsel. We offer legal clinics and one-on-one legal advice for a variety of legal issues, including family law, such as divorce, child custody or support, adoptions, domestic violence restraining orders. We offer services for name changes or birth certificate changes, for criminal expungement, credit and debt relief, bankruptcy, immigration issues, and landlord-tenant issues. Now let's turn to Certificates of Rehabilitations, or COR for short. A COR can restore some of the rights you lost as a result of your conviction. For instance, when you apply for a job or housing, a COR serves as official proof of your rehabilitation. If you apply for a professional or occupational license, a COR improves your chances of getting approved. If you are required to register as a sex offender under California Penal Code Section 290, a COR may eliminate your registration requirement. And finally, a COR serves as an automatic application and recommendation for a full pardon from the governor. While there are many benefits to obtaining a COR, it is a limited remedy. There are many things that a COR does not do. For example, it does not erase or seal your conviction. It does not restore your right to vote, though this right will return after your supervision. It does not prevent the conviction from being a prior in a subsequent sentence. There are some sex offender crimes that are not eligible for a registration waiver. And you'll still have to disclose the conviction when you apply for jobs, housing, and professional licenses. You are eligible to apply for a COR if you fall into either of two categories. The first category is if you are convicted of a felony and cannot expunge or dismiss the conviction. Note that you are not eligible for a COR for sex crimes where the victim was a minor, where the sentence included mandatory life parole, where the sentence was the death penalty, or while you are currently in military service. All of the following must be true to be eligible. You are convicted of a felony. You served your sentence in a California state prison or county jail or some other Department of Corrections facility. You completed your sentence and were released from prison or released on parole. You have not been incarcerated in any California state prison or other Department of Corrections facility since your release. And you have lived in California for the last 5 years. Category 2 requires that your conviction is expunged under Penal Code 1203.4. All of the following must be true. You are convicted of a felony or convicted of a misdemeanor sex offense. Your conviction was expunged under California Penal Code Section 1203.4. You have not been incarcerated anywhere, so not in any prison, jail, or other correctional institution since getting your conviction expunged. You are not on probation for any other felony, and you have lived in California for the last 5 years. Because a COR is only available for the misdemeanor sex offenses defined in PC Section 290, if you are convicted of a different misdemeanor, the COR is not the appropriate remedy. See our video on how to expunge a criminal conviction for more information. A felony that is able to be expunged is typically one that could have been charged as a felony or as a misdemeanor, what is often called a wobbler. If your conviction is eligible for an expungement, you will likely be required to do so before the judge will grant a COR. If you have been convicted of a crime that does not fall into either Category 1 or 2, you won't be eligible for a COR. Instead, you would have to petition the governor directly for a pardon. Note that the governor grants direct pardons very rarely. To distinguish between the categories, you qualify for Category 1 but not 2 if you are convicted of a felony and have not expunged it. You qualify for Category 2 but not 1 if your conviction was for a misdemeanor sex offense and you have expunged it. Before you can apply for a Certificate of Rehabilitation, you must complete a period of rehabilitation to show that you have improved your life and avoided involvement in any more criminal activity since your release from prison or jail. In general, you must wait a minimum of 5 years before you can apply for a COR, plus an additional number of years depending on what your conviction was for. You must also have completed your parole or probation term, but your period of rehabilitation starts running as soon as you are released from prison or jail and includes any time you spent on supervision, such as parole or probation. The process for requesting a COR is the same, regardless of whether you are requesting it early or at the end of your period of rehabilitation. The period of rehabilitation depends on the offense for which you were convicted. The minimum term is 7 years, but there are exceptions. A person convicted of the Penal Code sections listed here, dealing with obscene material or acts, must wait 7 years. All other offenses that are not listed below are also eligible for a COR after 7 years. There is a waiting period of 9 years for these listed sections, which include murder and attempts, military sabotage that leads to bodily harm or death, as well as any offense that is punishable by a life sentence. There is a 10-year waiting period for most sex crimes, but the exceptions listed here only require the minimum 7-year waiting period. Even if you have not completed your entire period of rehabilitation, you are allowed to request a COR early as long as you are not required to register as a sex offender under PC Section 290. The judge may grant you a COR early if she or he finds that it is in the interests of justice to do so. The judge will consider your good conduct, rehabilitation efforts, and how important getting a COR is to your success in the future. While you are allowed to apply for a COR if you have a new conviction during your period of rehabilitation, the judge will likely use the new conviction as a reason to deny your COR and can require you to complete a new period of rehabilitation starting from the date your COR is denied, not from the time of the offense that led to the denial. In addition, even if you get the new conviction expunged, the judge can still consider the conduct that led to the conviction when deciding whether to grant your COR. The judge has discretion to consider every interaction with the law when determining whether to grant a COR. Evidence presented at a COR hearing includes records from parole and probation, which would include any violations of your conditions, as well as written reports or records of any other law enforcement agency about you. Now let's talk about the nuts and bolts of getting a Certificate of Rehabilitation. If you meet all the requirements for a COR and you have completed your required period of rehabilitation or want to request a COR early, you will need to file papers, which are called a Petition for Certificate of Rehabilitation, in the court in the county where you currently live, not where you were convicted. Your petition will explain why you deserve a COR. It should include letters of support and proof of your accomplishments. The district attorney will likely do an investigation and prepare a report about you. Then you will have a hearing where you will have to convince the judge that you are rehabilitated and ready to be a responsible member of society. Step 1. Work with an attorney to confirm you are eligible for a COR. First, get your criminal record report so that the attorney can make sure they know your complete history. Your record of arrests and prosecutions, or your rap sheet, will contain all the information about any arrests, convictions, and sentences you have in California. If you are being represented by a public defender for a COR, make sure they know they can get your rap sheet free of charge. To do so, they must send in a request citing the penal code listed here and the 1991 case People v. Weber. They may also need to obtain a judge's signature and/or a certification of attorney of record containing a court stamp or seal. If you want to get your record for yourself, check out our video on how to get a rap sheet. You have the right to a lawyer to help you with your request for a COR. You can hire a lawyer of your choice, or if you cannot afford a lawyer, the court must assign a public defender or another lawyer to help you. If you are just getting started and don't yet have a lawyer, you should start by contacting the public defender's office in the county where you currently live or Sacramento Justice League. You also have the right to get help with your request from the county probation department, state parole officers, the California Youth Authority if you are under 30 years old, and any other rehabilitative agency. Preparing the petition is likely the most challenging part of the process and takes several steps. To be ready, you'll need to write a personal statement which should explain to the court how you're rehabilitated, as well as gather support from friends and acquaintances that can attest to how you've changed. You also need to fill out the paperwork for the court and notify the governor and the prosecutors who were involved in your criminal cases. You should include a personal statement in your petition. The judge wants to know that you are truly rehabilitated, so you'll need to show that since your release from prison or jail, you have lived an honest and upright life, you have behaved with sobriety in industry, you have shown good moral character, and you have obeyed all laws. The judge will consider all of these factors when deciding whether or not to grant your COR. Therefore, your petition should emphasize all of the positive things that you've done since your conviction, both while you were incarcerated and since your release, such as your efforts at rehabilitation, any treatment or behavioral programs that you've completed, how long you've been sober, etc., what you've learned and how you've changed since your conviction, the successful completion of your sentencing and supervision requirements, and any other accomplishments since your conviction, such as your job, any school achievements like classes, a GED, or a degree that you've completed, volunteer work, community involvement, including church, youth groups, mentoring, and your family life. If you are requesting a COR to help improve your employment opportunities or for getting a professional or occupational license, make sure you say this in your petition. If you have had any new convictions or violations while on supervision, make sure you explain them, why the conviction happened, what you are doing differently now, and why you will not have the same problems again in the future. If you are currently required to register as a sex offender for your conviction, you must also convince the judge that you do not pose any threat of committing any sex offenses against children. In addition to your own statement, you should include as many letters of support and proof of your accomplishments as possible. You can ask folks like current and previous employers, friends and family, a mentor or a sponsor, a faith-based leader, teachers, counselors, community leaders and members of community organizations, or honestly anyone else who can speak to your character and rehabilitation efforts and will be seen as credible by the court. Have a variety of people write letters for you. You should have letters from people who know as many different aspects of you as possible. Don't get all of your letters from people who know all about you from the same activity or area of your life. You should make this request as easy as possible for your supporters. Remember that people are busy and letters of support can take time to write. Some ways you can make it easier for the people you are asking to help you are to give them plenty of time. Don't ask them 2 days before you need to turn in the letter. Give them plenty of time to work on it so they don't feel rushed and can put thought into what they're writing. Give them plenty of information. Make sure to remind them of the things they can write about, such as your accomplishments or your positive impact on them. Give them friendly reminders. If someone hasn't responded to you or hasn't given you a letter by the date you asked to have it done by, try writing them a quick email or calling them. Be polite, but not demanding. Your message should be along the lines of, "Listen, I know you're busy, but I was curious if you'll have any time to work on that letter of support I asked you about." And finally, keep it short. It's best to keep the letters short, about 1 to 2 pages. This will make them easier to read and also less time-consuming to write. A letter from an employer or previous employer should explain how they know you and how long they've known you. It should explain who they are to establish their own credibility. It should give specific information and details about your employment, your wages, your length of time employed, your responsibilities, and how you've performed. And they should also tell why they think you're worthy of a certificate of rehabilitation. They should thank the reader for consideration of their letter, and they may also want to mention that they are available to provide further information, and they could provide their phone number or other contact information so that they can be reached. A letter from anyone else should define their relationship with you, should give specific details about who they are and how they know you and how long they've known you, and give the reader a reason to respect their letter of support through their career, community involvement, education, etc. Again, they need to establish their own credibility. It should also give specific information and details about you, focusing on how they have experienced your positive personal assets. They should also talk about why they think you should get a COR. And then thank the reader. They may also want to mention that they are available to provide further information and provide their phone number or other contact information. After you've completed your personal statement and gathered your letters of support, you'll need to get and fill out 2 forms for your petition. The first is a notice of filing, which identifies the parties you will need to notify that you're applying for a COR. And the second is the actual petition. You will also need to get a proof of service form, but you don't fill that out yet. You can get the forms from the court clerk, the county probation department, the public defender's office, or you can download them from the Sacramento Law Library website. You can see the link in the description below. The petition and the notice of filing look very similar, but they serve different purposes, so you need different information to complete each of them. The petition is the actual application for a COR that you will submit to the court. The notice shows the court that you notified the other parties in the case. Here it will be the governor, the district attorney where you are applying for the COR, and the DA of any county where you were convicted of the relevant crimes. To complete the petition, the county you are filing in, which is the county that you currently live in, goes at the top. Your name, date of birth, criminal identification and information, or CII number, from your rap sheet, and all case numbers you are requesting to be resolved by the court also get put at the top. On the rest of page 1, enter in the information about your most recent conviction, which is also located on your rap sheet. Then describe your sentence as well as when you were released and whether you served parole or probation after your release. The second page gives space for a second or third conviction, if that is relevant to your situation. The third and final page requires you to put the date that you most recently moved to California. You must also sign, enter today's date, as well as your address. Now let's talk about filling in the notice. Again, you'll put the county where you're applying for the COR, your name, your CII number, and case numbers. But unlike the petition, you'll indicate all the counties where you have to notify the DA. For the bottom half of the page, skip the hearing information until you take your petition to the courthouse. That's because the court clerk will give you the information about your hearing date. After you've gotten that info from the court, you can then sign, date, and write your address. You should now be ready to file your papers with the court. You will need 3 copies, so make 2 copies of your petition packet as well as the notice. Then take all of the documents to the criminal filing desk in room 102 of the Sacramento County Superior Court. In that room, you can use a 2-hole punch to punch the top of the originals. Staple the 2 copies so you have 3 packets, the hole-punched originals and the stapled copies. Take them to the clerk at the desk. The clerk should file them and shouldn't charge you a fee. The court will assign a hearing date, time, and department and note these on the notice. Make sure the hearing date is written on the notice, either by the clerk or by you. The court clerk will also stamp the petition and keep the original, but return the copies to you. Now let's turn to how to notify the other parties. As a reminder, at a minimum, you'll have to notify the governor and the Sacramento District Attorney. Again, these forms look similar, and this time they will contain some similar information. The difference is the way you notify the other parties. You are allowed to notify them both in person and through the mail, but you are only obligated to do one of the two. Either way, it is important to note that if you are the person seeking a COR, you cannot be the person that serves notice to the other parties. You can either ask someone you know who is over 18 to help you, or you can hire a process server. If you serve the DA yourself, they can ignore the notice and you'll have to do it properly. Because you have to notify the other parties at least 30 days before your hearing, you will have to start the whole process over again. It is worth doing it correctly the first time. You need to make enough copies of the notice and the petition for all the other parties, because you are required to leave a copy of the notice with them. It's also courteous to give them a copy of the petition. For in-person service, the process server brings this form, along with the notice and petition, to the correct offices. The address of the Sacramento District Attorney and the Governor are in the description below. The server asks the staff person to fill out their section of the form with their name, signature, and date. Have all the offices fill out the same form. Then remember to leave a copy of the notice and petition with the office. For service by mail, the process server brings this form along with the copies of the notice and petition to a notary public. You can find a notary at a mailing store or online, or ask the process server to do it for you. The server puts his or her name and address at the top, the date, and who is being served. The notary fills out the bottom. He or she will require that the server prove they are who they say they are, so make sure the server brings a photo ID with them. The server can then mail the notice and petition to the other parties. Again, the address of the Sacramento DA and the Governor are in the description below. Once the Governor's office and the appropriate district attorneys have been served, make 2 copies of the notice and the affidavit of service by mail, or notice of service in person, depending on which method you chose. Then go back to the courthouse and file the original plus the 2 copies with the court. The court will stamp and return the copies, but keep the original. After you file your petition, the judge may ask the DA to do an investigation of your life, conduct, and rehabilitation since your release. As part of the investigation, the DA may contact you directly, may talk to your family, employer, and neighbors, and may also get any records or reports related to your conviction, including trial documents, prison records, and probation or parole reports. Afterward, the DA will prepare a report for the judge, which will help the judge decide whether to grant you a COR. You then need to go to your court hearing on the date and time the clerk gave you. Remember, the hearing is your chance to make a good impression on the judge. During the hearing, the judge will consider your criminal history, your behavior in custody, and your conduct since your release. The judge will look at any reports or records from the district attorney's investigation and may also ask you or other people to answer questions. You should be prepared to answer any questions from the judge about your conviction, your life and conduct since then, and any information in your petition. Just like in a criminal case, make sure to stay calm and respectful no matter what is said about you or your past. In order to grant your COR, the court must find that you are rehabilitated and ready to be a responsible member of society. In other words, that you are ready to have all the civil and political rights of citizenship. If you are required to register as a sex offender due to your conviction, the judge must also find that you do not pose any threat of committing any sex offenses against children. If the judge grants your request for a certificate of rehabilitation, the court will send you your certificate and will also send a copy to the governor's office. The COR serves as an official recommendation from the judge that the governor grant you a full pardon. The COR also automatically serves as your application to the governor for a pardon, so you will not have to do anything more to apply for one. If the judge decides not to grant your certificate of rehabilitation, you can reapply for a COR any time in the future. However, pay attention to the judge's reasons for denying your request so that you can fix or improve them before you refile. This will increase your chances of being granted a COR the next time. If the judge sets a new period of rehabilitation for you because you served consecutive prison terms or have a new conviction, you will need to wait out this additional period before you can reapply for a COR. That's all for this video on obtaining a certificate of rehabilitation and a governor's pardon. If you need your rap sheet to start the process, check out the video, How to Get a Rap Sheet. If you didn't spend time in prison for your offense, you may be eligible for expungement, which is an easier process that doesn't require the lengthy period of rehabilitation. Check out the video on reading your criminal record report and filing a petition for expungement. If you have any other questions, reach out to us by phone, at our website, by email, or through the Postal Service. And special thanks to Root and Rebound and the Sacramento Law Library. Both organizations were incredibly helpful in creating this presentation, as well as the other presentations in this series. Please check out the links to their websites in the description below for more information. And finally, we hope you find this video helpful on your path to getting your life back on track, and we wish you all the best in cleaning your record.